folks have joined that are going to. As an initial housekeeping item, this meeting is being recorded. These webinars are for public access, and so we do record them and post them afterwards to our YouTube channel, Cal Voices on YouTube, along with the slide deck. Captions should be turned on. We don't allow AI note takers in the Zoom meetings because they don't transcribe accurately. But again, this whole meeting is being recorded and the slide deck will be available. And the caption should be on. So hopefully that mitigates the need for AI note takers, and folks can review content on YouTube if they want to revisit it. So welcome everyone again, and the policy update for today, as I mentioned, will be recently introduced bills into the legislature focusing on behavioral health. It is very early in the legislative session, and the deadline to introduce new bills has not even passed yet. So we will probably see additional bills of interest or bills change significantly as the session goes on into the fall. My name is Claire Portright. I am the Advocacy Director at Cal Voices. And Access is a program funded by the, I think they're called the Commission for Behavioral Health now, formerly the MHS-OAC. So Access is to empower local level advocacy, and any policy positions are the positions of Cal Voices and not the positions of the Commission, which is an entity for the state of California. You all should have had a poll pop up for you. This is demographic information for us to know who comes to our webinars, and to be able to provide content going forward that's relevant to folks. So if you wouldn't mind completing that short poll, it really helps us. And I will give another minute or two for that so folks aren't distracted when I jump into content. Okay, I think we're mostly good on the polls being completed. So the bills that we're highlighting in this policy update are ones that we're currently tracking. The legislature introduces typically around 3,000 bills a year. So, and behavioral health is a very hot topic. So you miss things and your friends tell you about them later. So this is a very short list for today. I mean, miss things when they're first introduced, and then you see something, or a bill is a spot bill and fundamentally changes and you find out it's really important. So this is the short list for today of things that we're initially tracking as we continue to watch bills be introduced and bills change. So this is a select list of things that are typically within our wheelhouse that we tend to track. And today we'll talk about AB 96 Jackson, which is actually a Cal Voices sponsored bill. And we did an access training about peer support. This bill does relate to peer support in CHWs. We did an access training about this last week. That was fairly long, about an hour and a half. It should be posted to YouTube along with the slide deck. So if you want to deep dive on what's going on there, that's available on YouTube. We'll talk about AB 225 from Mia Bonta, AB 384 from Connolly, 416, 27, 28, and 84. And there's a short description of what they are, what their subject area is. So first, the Cal Voices sponsored bill, AB 96, which was introduced for us by Assemblymember Corey Jackson, and we're grateful he's carrying the bill. In California, we have a Medi-Cal paraprofessional provider type called a community health worker who can provide preventative health services in what we call Cal-AIM, or our Medi-Cal's managed care plans, to persons with mild to moderate and mental illness or SUD, and CHWs can also provide targeted preventative health services for persons with serious mental illness or substance use disorder. In our specialty Medi-Cal plans, which are run by counties for people with serious mental illness and drug Medi-Cal. CHWs are paraprofessional types, so they don't have to have like, you know, an LCSW or a particular educational degree to be able to provide these health services. They are qualified by their lived experience and intersectional identities. So they're folks with lived experience of health conditions, and they will have a shared linguistic or cultural or racial background with the folks that they're serving. So the idea is to sort of match providers with a certain intersectional identity and lived experience with folks they're serving. So they are similar to Medi-Cal certified peer support specialists in that they are a paraprofession with a lived experience requirement. Peers, you know, persons with lived experience of serious mental illness or SUD, what we call peers, are eligible right now in the law to get a CHW credential, right? They can go get that credential. They can also get a Medi-Cal certified peer support specialist credential. These two paraprofessional provider types can bill in different ways, though. CHWs can provide preventative services in the managed care plans and targeted prevention in the specialty plans. Peers, on the other hand, can only provide peer support in the specialty plans, and they cannot provide peer support or any services to folks with mild to moderate mental illness in the managed care plans. So that's a lot to follow, but just basically all this bill is doing, it would amend the definition of a CHW to allow those who've already achieved an MCPSS to have that certification recognized as fulfilling the requirements of the CHW provider type. And this would allow people who are certified as peers to provide preventative health services in the managed care plans under the banner of CHW and targeted preventative health services in specialty mental health and drug Medi-Cal under the CHW classification. It does not eliminate peers. It just gives folks who have that credential and are eligible to be CHWs too, necessarily to be recognized automatically. So they don't have to achieve 2 certificates to be able to serve more folks with mental illness in different places in the system. Any questions about that one before we move on to the next one? I am not seeing hands on that one right now. Let me check the chat. Oh, there's a hand. Jenna, go ahead.
Hi, good morning. I'm not familiar with the schedule. When will we know what the updates are on this particular law?
Okay, that's a great question. So the legislative session starts right at the beginning of January. The bills are introduced either on the Senate side or on the Assembly side, and then they have to make it through their house, be introduced in the second house, pass the floor in both, and get signed by the governor. So that whole process, I'm not sure exactly when the session ends this year. It usually ends, last year it ended end of August. Year before that, I think it was September 14th. So between now and then, that's when this bill is being vetted through the legislature, voted on in various committees. And if things change with respect to it, you don't exactly know when because they change in the committee process. But what you can do if you want to see this bill progress is Google California Legislative Info. It is the California State the California State Legislature's website, and you can search for the bill by its code AB 96 and the year 2025. And it will have a little link where you can sign up for alerts on the bill, what's going on with it. You put in your email, and then that website, LegInfo, will send you an alert. Here's what's going on with the bill. Is that helpful?
Yes, very much. Thank you.
You're welcome. Okay. I don't see any other questions about that one, so we'll move on. This has just been introduced. It's AB 225 from Mia Bonta, and it affects the patients' funds that are held in trust at state hospitals. So folks that are conserved or in the criminal justice system and have serious mental illness will oftentimes be committed to state hospitals for periods of time. And if those individuals have money, they have benefits, they have some source of money, some of that money is that belongs to patients put in a fund called the benefits fund. And the administrator of the hospital can spend out of those funds for the education and entertainment of people who are institutionalized. And this bill would expand the list of authorized uses of those patient funds held in trust to include spending for the welfare of patients. We don't know the definition of that yet, but it is a bill that we are watching. Any questions on that one? Okay, I'm not seeing anything. And thanks for whoever put the link to Ledge Info in the chat. The next one on our list is AB 384 from Connolly. This bill has to do with what's called prior authorizations. So private and public health insurance plans, if a person is going to be hospitalized in a psychiatric hospital, or there is such a thing now as a chemical dependency recovery hospital in California, if you're going to be inpatient hospitalized on a voluntary or an involuntary basis, the insurance company has the right to make determinations about whether they are going to pay for that, whether it is considered medically necessary by them under the rules of the insurance plan. When the insurance company is making that determination before you get the service, it's called a prior authorization. So basically, there's a process by which the doctor is communicating with the health insurance company and saying, I think that this patient needs to be admitted. It's medically necessary. The insurance is reviewing it and saying, yes, we agree it's medically necessary, or no, we don't, and we're not going to cover it. So it's a controversial, prior authorizations are a controversial topic. A lot of people don't like them. What this bill would do is remove, it would not allow private health insurance plans, but also Medi-Cal public plans to use prior authorization for people who are being admitted to an acute inpatient psychiatric or SUD hospital. So that it would eliminate the process by which the doctor communicates with the insurance company and there's a determination by the insurance company in advance that the hospitalization is medically necessary. Also, for Medi-Cal patients, it would eliminate prior authorizations for any treatment that happens while you are in that acute psychiatric hospital or SUD hospital. Of course, I should say prior authorizations are just one part of the process, right? Prior authorizations are before you get care. After you've received care, the insurance company still has the ability to do its review of the medical necessity of that care and either accept or deny the claim to the insurance for that care. So that's one we're watching. Does anyone have any questions about that one? Checking for hands, not seeing any hands. Okay. AB 403 is another bill that we're watching. It does affect CHW, so it would affect AB 96, our Jackson bill. And what's happening here is, as I mentioned, community health workers are a paraprofessional Medi-Cal billable provider type. They don't just practice in mental illness or SUD. They can serve folks for preventative health services with a unlimited range of medical conditions, including like diabetes or MS. They can really serve any persons with any type of medical condition, as long as those persons are eligible for the service, and those eligibility criteria tend to be like, you're a high utilizer of services. Maybe you're going to the ER a lot, or you might need some additional support out of the medical system in a non-traditional fashion. So that is one of the roles of CHWs. So what this bill would do is it would require the California Department of Healthcare Services, who's sort of the regulator, the people that look at and have oversight over managed care plans, to review the outreach and education of the managed care plans regarding CHW services and publish them to the legislature. That was probably not really clear what's going on here. So basically what's going on here is CHW services are available in the Medi-Cal managed care plans. So that means, it could be your county that's providing all of your Medi-Cal for physical health and mild to moderate mental illness, or they could have farmed it out to a commercial insurer. So it could be you're on Medi-Cal, but you have Kaiser Permanente or you have Anthem. And those managed care plans are able to offer CHW services and let their members know, hey, this service exists and it's billable to your insurance and you're eligible for it. But the managed care plans have not done a great job of telling members, hey, this benefit exists, even though the law directed them to. So I take this bill as it seems like it's another way to ask the Department of Healthcare Services for help in getting the managed care plans to let members know that CHW services are available, that they can be billed through insurance and do those things they were supposed to do to implement CHW services in those managed care plans. Does anybody have any questions about that one? Not seeing any. Okay. This is a bill relating to 5150 holds. It's AB 416. I can't even see the author because I need to move my bar. It's Krell. So most folks are familiar a little bit with 5150 holds in California, those 72-hour involuntary psychiatric holds. Our existing law in the Lanterman and Petrus Short Act allows providers that are listed in the law to place persons on involuntary 5150 holds. And our existing law allows a professional person in charge of a facility designated by the county for evaluation and treatment, or a member of the attending staff at that facility, or other professional persons designated by the county, mobile crisis and cops. They can all place 5150 holds. So what this bill does is add to that list that emergency physicians, who, they're what we think of ER docs in a regular ER, what we think a general acute care hospital, what we think of as a regular medical ER. This bill would allow those persons to place 5150 holds in the ER explicitly. I have to say, because I've practiced extensively in the real world in this stuff, that I don't think this is actually a fundamental change to the law. I think it's a clarification of something that is already done and is already, in my view, allowed under the law. So I don't see this as really changing that much on the ground. Technically, we shouldn't be writing holds at places that the county hasn't designated as safe and appropriate for mental health treatment. Many of our ERs are not designated for that purpose, but they are now designatable under a new law last year. So in my real world experience, ER physicians, LCSWs in the ER, in regular ERs, place holds all the time, even though many of those hospitals are not designated as where you should be for mental health or SUD treatment. That's just that's my 2 cents, that I don't think that in the real world this is going to, actually create a new class of persons that previously weren't writing holds. I think it just clarifies that we think ER docs can do it. There may be some upshots to it, because sometimes if a hold is written in the ER, or if someone is placed on a hold and brought to the ER, there has been some confusion in the past about whether ER doctors can drop the hold, which they absolutely can. But so this may be helpful in that regard in clarifying that an ER doctor can also drop a hold if they want to remove the hold. Any questions about that one? Check the chat. I am not seeing questions about that one. Oops, did I skip forward too much? Nope, just one. Okay, so all those AB bills, those were introduced in the assembly by assembly members. These are the Senate bills introduced by senators in our Senate. I gotta move my stuff again. Oops. So SB 27 from Senator Tom Umberg changes some of the due process in the CARE Act. So CARE Court due process is just what lawyers refer to as the entire procedure of the court case, right? So how you get notified that you've been petitioned into CARE Court, how your attorney is assigned, when you get notice of a hearing, when you're supposed to be at court, what is going to happen when you go to court. All of that is kind of what we call due process, and it's the procedures by which we determine, okay, do you meet legal criteria to be in this process or not? What's the evidence that you do? Do you want to test that evidence and challenge it or not? So SB 27, what it does is kind of collapse the timeline on some of this stuff. I don't love it, but I never love these. That's just my personal opinion. So what it does is how the procedure works in CARE Court, the basic procedure, last time I checked, they change it a lot, is someone files a petition saying that you should be in CARE Court. And they have to file a bunch of documents that make specific claims about what's going on with you, your diagnosis. And those documents are given to the court, and then the court looks at the documents. There's no proof yet. They just look at the documents to say, did you kind of say, did the petitioner, the person who's filing the petition, did they say all the magic words that would, just on the face of these documents, show that we can proceed, this person is at this stage of the process eligible to be in CARE Court. That's called prima facie evidence. And it means just looking at those documents and making sure that the documents are in order. And then if those documents are in order, then the judge can set an initial appearance. So that's the first time that the person who's the subject of CARE Court has to show up in court. So what this bill is doing is collapsing the timeline so that the day that the judge is looking at the documents to see if they're in order is also the day that they can do an initial appearance. I frankly don't understand how this works under the existing CARE Act order, because they're supposed to tell you, there's a petition and give you time to give you notice and give you time to come to court. So I'm a little bit concerned about this because I don't see where people are getting appropriate notice before an initial appearance. Don't know, but that's one that we're watching. Another one that we're watching that may be of interest to folks who have been seeing what's going on with Prop 36 is SB 28, also from Tom Umberg. And this is about ostensibly, it's about drug treatment court standards. For those who are not familiar, Prop 36 was a ballot initiative, not through the legislature. So basically, people who wrote Prop 36 and wanted it to get passed went and collected enough signatures from voters to qualify it to go directly on our ballot. And it did go on the presidential ballot in November. And so basically what Prop 36 did was repeal some of the reductions in sentences for primarily retail theft under a different ballot initiative from, I think, 2014 called Prop 47. So Prop 36 repealed some of the criminal justice reforms of Prop 47. So it allows folks to be charged with felonies for retail theft who previously would have been charged as misdemeanors. It also defunded some SUD and mental health treatment funds that were related to Prop 47. And then it also, for folks that are, have been convicted twice of certain felonies and are facing a third where there's substance use involved, they will have a choice to either go to a state prison or be diverted into a drug treatment program called a treatment mandated felony. And the big thing with Prop 36 is because it did not go through the legislature where it could have received funding for these drug court treatment programs. It went directly on the ballot, as is with no funding. So there is a big fight between the Democrats who mostly opposed it, including the governor, and the Republicans who really wanted it passed, about who's going to fund the drug treatment that is a treatment mandated felony under Prop 36. So this bill affects that. And it affects other things. So what it does is existing law allows, it amends an existing law, and that existing law allows counties at their choice to implement drug treatment courts that you can go do drug treatment instead of taking a criminal conviction. And what this bill does right now, and I expect that it'll change a bit, it, instead of making it an option whether counties have drug court as a diversion program from criminal charges, it actually mandates that counties have a drug treatment court to divert criminal defendants, and not just those charged under Prop 36, but all criminal defendants, including those charged under Prop 36. So here's the thing, when the state tells the counties that it has to do certain things that cost money, usually the state has to give the county the money to do it. So again, this is telling counties they have to stand up drug treatment courts if they don't already have them, but it is not giving them money to do it. And I know that people have been looking at Prop 1, the Behavioral Health Services Act dollars that can now, after like the MHSA, you could not fund programs and services for folks who didn't have a mental illness and only had a substance use disorder. Prop 1 changed that. The BHSA can fund programs and services for people who only have a substance use disorder. And right now there is no firewall between those services being court ordered and involuntary, including through the criminal justice system, or voluntary. So basically those BHSA funds technically those county funds can probably be used for these criminal diversion programs, but that reduces access to folks that aren't in some kind of court order program. Don't know what's going on there. But that's definitely one to watch. And I could go on about why I don't know which way it's going to go, and also why it's kind of controversial, with Prop 1, because technically the state allowed the counties to fund SUD programs and services with BHSA dollars and did not require them to do it. So now if they're getting a requirement to fund a drug treatment program and the BHSA dollars are on the table, is someone trying to sneak an unfunded mandate on the counties? It's a bit of a policy nerd position, but that's kind of what's going on with that. And I will take questions. It looks like Michael Lim has one. Go ahead, Michael.
Hey Claire, good to see you again. My question kind of stems from you talk about money not diverted to the county to do to enact certain parts of the law. So going back, is it okay if I ask questions about the emergency holds a few slides back?
Absolutely. Yeah. Do you want me to skip back to it?
Oh, no. That's okay. Just stay here.
Okay.
So the current law we have is 5150 for 72 hour hold. And then if needed, they can extend it to the 14-day hold. And then if needed, there's the 5270, which is a 30-day hold.
It's all correct.
And it's my rather new understanding that 5270 is something that that the county can choose to enact or not.
That is correct.
And so so that has to be voted by what, the Board of Supervisors to, okay.
Correct.
So could you, if you have time, that is, maybe give us the advantages or disadvantages of the 30-day hold, because I believe my county is beginning to look into that.
Yeah, because that relates to 5270s, I'm gonna hold that until after, unless I will, I will talk to you about that. But I just want to see if there's any specific to the Prop 36, or if you have any questions specific to Prop 36. But if we're kind of, if it's a wrap on these bills for this, uh, for this webinar, I'm happy to stay on, after we stop recording and talk about the 30-day holds. But I will say, the bill that I was talking about with respect to 5150 holds, this would not allow, which one was it? Nope. It's this one. So AB 416 would not allow an ER that was not designated for mental health treatment to like place a 30-day hold or a 2-week hold, or anything of that nature. This bill would only affect 72-hour 5150 holds.
Okay, thanks. I'll
Okay.
wait.
Yeah, no worries. Does anyone else have any other questions about any of the bills that we talked about today? Or any bills they may be aware of that we are not yet aware of because it's early days? Okay, I am not seeing any more hands, or anybody else in the chat. Thank you so much for joining us. Again, this will be posted to the Cal Voices YouTube channel along with the slide deck. If you would like to receive email alerts from Access for further webinars, you can email us and sign up on our website. And thank you all so much for being here. I'm going to stop recording, and folks that want to stay on and have a conversation about 5270s are welcome to.